Welcome to the Case Autopsy, the Verdict and Settlement podcast. With your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your host, Mike Campbell.
Hello and welcome to another episode of Case Autopsy. This is your host, Mike Campbell, and I'm joined today with a guest co-host, Heidi DiLorenzo. Heidi, how are you?
I'm good. Thanks for having me, Mike.
Heidi, tell us a little bit about your practice and where you practice and what kind of cases you handle.
Sure. I am in Birmingham, Alabama. I work at Alexander Shannara Trial Lawyers, and I'm a trial lawyer. I handle mostly motor vehicle wrecks and trucking litigation. Some premises liability, but mostly my focus now is on trucking litigation.
And so you're down in Alabama, and you I'm guessing you probably have to deal with some conservative juries down there.
Oh yes, definitely.
And so when you hear me or anyone else from Missouri bemoan the fact that we have to deal with conservative juries, you're dealing with the same thing. Yeah.
Keep in mind that I'm further south.
I
respect the jury.
Yeah, exactly. Do you, one of the things that I know about you is you teach, I think, as well, right? And I know you're on faculty for a lot of AAJ stuff. So why is that important to you?
So I'm on faculty for AAJ, and then I also teach depositions at my law school that I went to, which is Cumberland School of Law in Birmingham. And I think it's important because I went to a school that is puts a lot of emphasis and focus on trial advocacy and on litigation advocacy. And I think that there are a lot of law schools who don't put enough focus on that. And I think that with AAJ, which I've loved teaching for AAJ, it's so important for us to reach out to other trial lawyers and to be available for trial lawyers who maybe don't get to try as many cases as we do or go to court as much as we do. And it's an important resource for them.
You know, I was talking with our mutual friend Tad about how no one's getting any trials in this year. Very few people are getting trials in this year. But the hope maybe is that on the other side of it, everyone new to more experienced, everyone's going to get into court because there's just going to be so many cases that we got to try.
Right. I was one of the lucky few. I tried one in January of this year.
Got one in.
And then did not. And then that's it. I've got one set in a couple of weeks, but it's been kind of we don't know what's going to happen with juries, and it's just been kind of unpredictable. But I think one really good thing about AAJ education is that they have made an attempt to keep going with their education courses, even though we can't meet in person. And I think you and I were both on a webcast faculty together.
Right.
And I think that's really important, and kind of a great thing about AAJ is that they've continued with that effort.
Yeah, and it's just total practical skills. And so if you're not getting in the courtroom, new or experienced, that these programs, I think, help anyone, no matter if you've been practicing for 30 days or 30 years.
Right.
So we've got Robin Clark coming up. She is an attorney with Frazier Clark, her law firm. And she's tried a lot of cases.
Yes.
And we're going to talk to her about a few cases that she's had within the past few years.
I've read some of the documents on these, and I'm looking forward to it.
Yeah, I am too. So let's jump in and talk with Robin.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Good afternoon. How are you doing, Robin?
Fine. Thank you for having me on your show.
You got it. Hey, why don't you tell us a little bit about your firm and what kind of cases you handle?
My firm is me, Robin Frazier Clark. I'm a plaintiff's personal injury trial lawyer here in Atlanta, Georgia. I've practiced for 32 years, and I do any kind of personal injury case, from car wreck, truck wreck, premises liability, products liability, medical malpractice, any possible thing where a person is injured through no fault of his or her own.
Sure. And you have a history of successes. I'll put that out there. I've read your bio, and I know about you, and former Georgia State Bar president, former president of the Georgia Trial Lawyers Association.
Right.
Really involved with those different organizations. Just curious, what drew you to get involved with those organizations, each one of them?
Well, I'll tell you, with Georgia Trial Lawyers, it came at a time when I was president. That came at a time when our association was not very diverse, and it took the president at that time, Ken Canfield, who is a very diverse, forward, very much in support of women and minorities. It took his reaching out to me and saying, we need more women involved, we need more minorities involved. Especially if you look at trial law, trial lawyers across the country only make up about 10% of the lawyers, that type of lawyers, about 10%. But women trial lawyers is about 1%. Huh. So we needed to have more women involved in our trial lawyer association. So Ken Canfield reached out to me, and it took a lot of very progressive males in our association to go along and say, yeah, we need a woman president. Ran for president and was elected with their help.
Fantastic.
But I credit my progressive ones, Ken Canfield, Nick Moratakis, Jay Cook, David Bell. Those guys all helped me because they're very progressive.
And it's awesome because, you have not just success in the courtroom, you have it out of the courtroom. And to have someone like you leading that organization, I think is a benefit to all the trial lawyers there in the state of Georgia.
One of the most worthwhile things I've ever done with my time as a lawyer, that and state bar. If you think about it, especially for trial lawyers, we don't pal around with each other on cases. We're not in depositions with each other. But for that organization, but for my time in Georgia Trial Lawyers Association, I would never have the chance to cross paths with some of the greatest plaintiffs' trial lawyers in our state.
Sure.
So that gave me the opportunity, and that's one of the ways I pitched GTLA is, other than this, you wouldn't have a chance to come across some of these great trial lawyers and make friendships and relationships. So many of these people who have practiced even longer than I have are some of my dearest, closest friends.
And when we talk about the cases that you have had, you've had quite a few notable cases, and that we're going to talk about two today. And one in particular got some national coverage, and I think I geek out about this stuff. I'm just going to tell you, I geek out about this stuff. I really like to read briefs and look at the lawyering involved. In this case, had fantastic lawyering, and we'll kind of get to that. But could you just set it up a little bit and tell us about the facts of the McIver case?
Sure. The McIver case, they even did a Dateline. NBC even did a Dateline, which shows you how
That's
sexy
awesome.
How sexy it is.
Yeah, sure. And that sort of, we're right there next to Dateline case autopsy.
Exactly.
Yeah.
Right.
So we're close.
That'll be really famous.
Oh yeah. Yeah. Past 2020. We're between Dateline and 2020. So yeah.
Great. Tex McIver is an employment, or was an employment lawyer here in Atlanta, had practiced for many, many years in a big, well-known employment firm for on the employer side.
Okay.
And he was married to a woman named Diane McIver. I think it is his second marriage. I think it was Diane's second marriage. And they did a lot of things together, and owned a farm out in, it may be Ocoee County. I'm not sure what the county, maybe Greene County, but at Lake Oconee, which is a very exclusive place, like that's very exclusive, about 70 miles east of Atlanta. So a lot of golf,
right?
lake.
Yeah, I could
gorgeous.
tell this guy had some financial resources.
Yeah, he may have actually been Putnam County. So there's several counties right there, but he may have been Putnam County. But yeah, he had they called it the ranch. And they played golf out there together. They rode horses. They practiced shooting guns. I mean, they did all kinds of fun stuff out there. Well, on this particular weekend, they'd been out there at their ranch and played golf on Sunday, and then came home. They lived in a condominium in Buckhead, which is another pretty well-known, kind of ritzy, affluent neighborhood where all the major shopping is in Atlanta.
Sure.
And they were going to come home and spend the night in Buckhead, and then Tex would just go on to work at his firm on Monday. And Diane worked for Corey Enterprises, a huge corporation here in Atlanta, does advertising, and she even was part owner of several of their different companies. I mean, she was a self-made woman, started there at age 19 as a secretary and worked her way up to being part owner of a huge corporation. And she would go to work on Monday. So they were out there, and they had their best friend, a woman named Danny Jo Carter, come out there and stay with them. And they had dinner on their way in to Atlanta at I think it was Longhorn Steak, a steak place. Tex and Diane enjoyed a bottle of wine together, not unusual. And because they had been drinking alcohol, they said, Danny Jo, why don't you drive home? Again, this is about 60 miles away from Atlanta. So Danny Jo said, sure. Danny Jo is driving Diane McIver's SUV. And it's now getting late. It's dark. They're coming home, and they come in from I-20 into downtown Atlanta. And there's construction going on I-20, and cars are backing up. So to avoid that construction, they get off a little bit earlier, get off I-20 at a exit, and the road they get on to go into downtown Atlanta is called Edgewood Avenue. Now, Edgewood Avenue, lots of businesses on Edgewood. It's a direct road right into downtown. I take it many times. For a period of time, my office is in downtown Atlanta, and I used Edgewood Avenue almost every day. But Tex says that when they pulled off, they have to go, when you pull off of Edgewood, you go under an underpass. A lot of homeless people live there. But Tex says that he saw a Black Lives Matter demonstration going on Edgewood. And we can debate whether that really was what was going on or what. But it made him worried, and he asked for his gun that he keeps in the center console. And Diane is sitting, Tex is sitting in the back, Diane is sitting in the passenger right seat, Danny Jo's driving. Diane picks up the gun, revolver, hands it back to Tex. And we think Tex had been dozing on and off for the hour ride back into Atlanta. But he now is holding his gun in his lap to protect his women. He told the girls in the car, hey, we shouldn't be in this area. I don't like it. Let's get out of here as soon as we can. So Danny Jo drove down Edgewood and would take a right on Peachtree Street, which is one of the main streets in downtown Atlanta, and goes north into Buckhead. And she probably could have gone Peachtree the whole way to their condo in Buckhead. And they get to Midtown, which is around 10th Street, from downtown to about 10th Street. And around that time, they had to stop. And the next thing you know, when Danny Jo comes to a stop at a stoplight on Peachtree, the gun goes off. And so you can imagine the sound inside of an enclosed vehicle, the gun going off. And Tex goes, everybody okay? Everybody okay? And Diane says, I think I've been shot. Tex, you shot me.
Huh.
And panic. Danny Joe's like, oh my God, what do I do? Tex says, let's go to Emory University Hospital. Drive her to Emory. So they're in Midtown Atlanta. Emory University Hospital is over in, it's east of Atlanta, about 6 miles. It may be in the city of Atlanta, but it's in DeKalb County. They're in Fulton County in Midtown Atlanta. Gun goes off. Tex says, I'm familiar with Emory. Let's go to Emory University Hospital, which is an interesting choice because in downtown Atlanta, closer, is Grady Memorial Hospital, a level 1 trauma unit and world-renowned for gunshot wounds in particular. So when anyone is shot in Atlanta, typically they go to Grady because those doctors see gunshot wounds all the time. Emory University is a teaching hospital. It is world-renowned, without question, great reputation, but does not handle gunshot wounds on a regular basis, if ever, and really just recently opened up an emergency room. So anyway, Danny Joe drives to Emory University with Diane bleeding in her car from a gunshot wound. At some point, Diane passes out, loses consciousness. They pull into Emory University Hospital emergency room. Tex is right there, and he actually gets out of the car. We have video of that, of him directing Danny Joe how to drive into the emergency room. They take Danny Joe in and immediately start working on her and trying to do whatever they can. The game plan eventually, had she survived, would have been to take her to Grady Hospital for work there because they know what they're doing.
Back to the other hospital.
Back to the hospital that was closer where she got shot.
Okay.
They are going to try to do surgery at Emory University Hospital, and they tell Tex, look, we've got to do surgery. They actually tell Diane, we're going to put you under anesthesia and do surgery on you. And do you want to see your husband? Tex, he's out in the waiting room. And Diane said, no.
Oh, wow.
I don't. So Tex didn't see her one last time. She undergoes surgery and essentially never regains consciousness and dies in Emory University Hospital. That
is crazy.
Meanwhile, at the hospital, the police, Emory University police, the Emory police are called, the campus police are called. They come over because it's a gunshot wound. They want to investigate. They realize, well, we really should call the Atlanta police, which they do. Atlanta police gets involved. And while all this medical treatment, emergency treatment to Diane's going on, the police actually take Danny Joe, her best friend and the driver of the car, down to the police station for an interview while her best friend is dying, which was traumatic, as you can imagine.
Yeah, sure.
They interviewed Danny Joe. It comes to light that at the hospital, Tex goes to Danny Joe and tries to convince her to tell the police that he was driving, not Danny Joe. Just tell him I was driving. And Danny Joe, to her credit, says, are you crazy, Tex? I mean, they know I was driving.
Right.
They have video of us pulling in. I mean, I'm not going to lie to the police.
Was he wanting her to say that she had the firearm too in the back seat or something, or?
He says he was going to try to tell the police that Danny Joe was not even present.
Oh,
but
okay.
But she's like, Tex, everybody knows I was there. I'm not going to lie. What are you talking about, man? So she doesn't do as Tex had requested. Later on, Tex will say, well, I'm just trying to keep Danny Joe out of it. I didn't want to because it's going to be so much trouble.
Chivalrous.
So
Diane
dies. And that's the criminal. That's a lot of the criminal case. A few days after her death, the police department, Atlanta police interviews Tex with his attorney present. And he gives a lengthy videotaped interview of what happened. He says, I fell asleep. The gun was in, the exact thing I've told you. I fell asleep. The gun was in my lap. I was holding it. At some point I was asleep and the car came to an abrupt stop. and all of a sudden the gun went off accidentally. It just shot her. And, I asked Danny Joe to drive her to Emory because that was the only thing I knew about. I'm familiar with Emory, and it just seemed the right thing to do. And so for a period of time, the Atlanta Police Department was not going to charge Tex with anything. Until some things started coming out, like he got appointed her administrator of her estate, and within a couple of weeks of her death, sold lock, stock, and barrel all of her belongings. And she was a wealthy individual. Her clothing was, I don't know how much they got for her clothing, but just, I think she had between 25 and 30 fur coats, mink coat. So he had an estate sale, all of her jewelry. He sold, and she had very expensive jewelry. He sold everything. Well, that was a
liquidated
everything, which was a red flag. So the police start interviewing people, investigating a little further, and Tex had a spokesperson come out and issue a press release because now it's in the news. This is big news, especially in the law world. But even it's on the news. It's on the nightly news here in Atlanta. In the law world, we're all talking about it. A press release comes out by his PR company that mentions that he asked for his gun in the car because he saw a Black Lives Matter protest. Well, let me tell you, that was a red flag for, you don't pull out a gun because you see a Black Lives Matter protest guy. That's ridiculous.
Yeah.
But it gave you a clue about what he was thinking.
Right.
And I believe that was the trigger for the district attorney's office to say, we're not going to let this white guy, very wealthy lawyer, get away with blaming it on a Black Lives Matter protest. Do that. So they started really digging. There was some evidence that there had been a second will in which Diane cut Tex out of her will. That was never found. They did all kinds of searches of every property owned. They never found a second will. But they searched for everything. During one of those searches for the second will, they did find another gun in his dresser. And he was under, when he was released on bond, one of the conditions was no firearms, no guns. Well, they found a gun, which put him back in jail until his trial. They revoked bond, the judge did. So district attorney ends up trying Tex for murder of his wife. And they present a case in which they try to prove it was intentional, that he intentionally shot Diane in their car. He thought that Diane was cutting him off. She made more money than he did. She's cutting him off. So to prevent that, he's going to kill her so that he would take under the first will. And that was their theory. Ultimately, he was convicted by a Fulton County Superior Court jury of felony murder. In Georgia, and this is probably something that I think needs to be changed, but the jury doesn't know the consequences of their verdict. So I think it was a compromise verdict, and they said, instead of finding him guilty of murder, let's find him guilty of felony murder. It's compromise. But in Georgia, felony murder has the exact same sentence as murder. And so Tex was sentenced to life in prison. And he may have a chance of parole, but he's 70-something. I think he has to serve 35 years before he would have a chance.
Elderly guy.
Yeah.
And so you talk about the criminal case where you've got this intentional act that he was convicted of, but in terms of the civil case, how does that, how do you get that in your office? And then in terms of any lawyer out there that's handling either a gunshot case or a similar case like this, what are you looking at when the case first comes into your office? Well,
we had all heard the story of Tex shooting his wife in a moving vehicle. So being a plaintiff's personal injury attorney who does a lot of car wreck cases, I immediately think, well, there's got to be some insurance for that. Who's got the car case? I mean, there's got to be a car case. The person who at that point, when Tex lost his bond was revoked, he's back in jail. Fulton County DA's office moved to have him replaced as her administrator. The person who was appointed administrator in his place is a lawyer, Mary Margaret Oliver, who's a lawyer and a state representative and a close friend of mine. I've known her for many years. And she's my state rep. I live in her district. And we were together one day and we were talking about how interesting this case is. And she was telling me about the estate and they were having to put together the property and this sort of thing. And I said, well, who's got the car case for the estate? And she said, what are you talking about? Because she's a trust and estates attorney, you know?
Sure.
She goes, what are you talking about? What do you mean car case? I said, well, a person was killed in a moving car. I'm wondering if there's insurance that would cover that. So that would go to the estate. She goes, knew nothing about this. Would you like to look into it? And I said, I would absolutely like to look into this.
Yeah.
So she, as administrator, hired me to represent her and the estate of Diane McIver to look in to investigate whether a lawsuit for wrongful death was possible. And that's where I come in and begin my work and my investigation, getting all the policies. And there was a Chubb policy on the car, and then a umbrella excess policy for $10 million that I argued also covered this incident. So we had a lot of litigation over that.
Yeah, because you had actually, it's like a multifaceted thing. You had Tex arguing that he should be the representative of the estate.
Yep.
Did they have children?
No children.
Okay, so
and Diane had no biological children ever.
So then Tex is coming in and saying, I should be the one who brings the claim.
Right, but I can't. And his attorney argued, but I can't sue myself. So dismiss Mary Margaret Oliver's claim. So I filed a wrongful death lawsuit on behalf of Mary Margaret Oliver as the administrator of Diane McIver's estate. Chubb appoints an attorney to represent Tex in that suit. I also sued Danny Jo Carter because she didn't call 911. She didn't do anything after Diane was shot in her car she's driving. So my suit is against both of them. Tex's attorney.
Can I ask you real quick?
Sure. Mm-hmm.
And so your case against Tex is for the wrongful death, and then you have a separate case against the driver for not getting her to this nearest hospital. That's a level 1 trauma.
Not even calling 911.
Not even calling 911. And so,
as I told the judge in state court, we're not best friends, Judge, but if you were shot in my car, I promise you I would call 911.
Right. And so you have now 2 claims, and are both of those claims you're seeking coverage under this Chubb policy for both of those and the umbrella?
That's right.
Okay. And so again, this is like the first instance of really good lawyering, because you're looking at the actions of the driver. What was her name again? I'm sorry.
Danny Jo. So you're looking at negligence for her, and then you got this other negligence thing, but the wrongful death, and we'll get to that in a second. But so you have these claims, and then Tex comes in and tries to get your case dismissed. Right. He's trying to get it dismissed. Move to dismiss. As did the driver, Danny Jo. They both filed motions to dismiss. Trial court judge denied those motions, and they went up on appeal. The wrongful death part went up on appeal. And that involves the Georgia Slayer Statute. Many states have a Slayer statute that says a person cannot benefit from killing somebody.
Sure.
That's
Makes
the Slayer.
Sense.
A lot of states have them, and we have one. Our statute, I don't know when it was enacted, but it has not been used very often. There's very little case law on our Georgia Slayer statute. So I put together an argument that said, because of the Slayer statute, Tex cannot be the person that brings the wrongful death case, even though the wrongful death statute says when a spouse dies and that person's married, the spouse has the cause of action for wrongful death. And that's statutory. And then it says, where there is no spouse, the next person the biological children. And Diane had no biological children. We just keep going down the subparagraphs of the statute. And the very last one, E, says, well, where there's nobody, who can bring a wrongful death suit. The administrator of the estate can. Okay, that gives me hope. I represent the administrator. But Texas' argument was, this is not common law. This is strict statutory law. And the statute says, if there's a surviving spouse, the cause of action survives in the surviving spouse, period. And there was a surviving spouse. But I used the Slayer statute to say, because he killed her, then he's going to be treated under Georgia law as having predeceased his wife. And the administrator steps in.
Oh, okay.
But he still argued, I'm the only one that can bring it under statute, and I can't sue myself, so lawsuit is null and void. That went to the Georgia Court of Appeals, and I won on that. And the Court of Appeals said, you're right, denied was correct, we're sending it back down for a trial, but because some equity is involved, we're going to transfer it to the Superior Court that is a court of equity. I had it in state court, which is not a court of equity. So it's going to be transferred to Superior Court.
And the Court of Appeals, like their opinion can be summed up in the one word, which was no, right? I read that decision and it just said, no, you can't get this dismissed. We're not going to have this. We're not going to have text in here.
Yeah, we're not going to have text in here. And part of my argument, equitable argument, was, Georgia has a very strong policy favoring the value of someone's life. We believe every person is of sacred worth in Georgia. And to say that because you're killed by your spouse, that you don't have a wrongful death suit to say what your full value of your life was, that goes against our policy of the value of life. And
that was that why it was important for you to bring this case?
Absolutely. To think that Tex could get away with killing his wife and that's it, I thought that was outrageous. I thought Diane deserved, she was a remarkable woman. She deserved justice in the form of a verdict by a jury saying what the value of her life was. She deserved that. And that's why I brought it.
And as you know, sometimes when the criminal justice system fails for one reason or another, the civil justice system has to step in and protect the value of that life and the injuries.
Absolutely.
And so there was, in this case, though, another prong that you had to overcome, which was coverage for the claims.
Right. So when I filed the wrongful death case, Chubb immediately filed a declaratory judgment action in the Northern District of Georgia in federal court. They argued two things, Chubb did. First, no duty to defend, which we pretty easily defeated. That was pretty easy. But then they were going to argue no duty to indemnify based upon his conviction in a criminal conviction. And they were going to try to use his criminal conviction basically like res judicata or judicial estoppel, that he had intentionally killed her because a Fulton County criminal jury had said so. And so that was really the huge argument. The bone of contention is, can they use a criminal conviction to show intent? And I argued absolutely not. We're talking about having a wrongful death trial in state court with a DeKalb County jury, different county, different jury, decide on a different burden of proof whether it was an intentional act or negligent act. And I was saying, we won't even discuss intent. My complaint didn't allege he was intentionally killing her. My complaint said he negligently killed her, just like he said he did. It was an accident. So we were only going to be talking about negligence in my trial, and then we were going to get a verdict, and it was going to be a large verdict, and then we would argue about intent or negligence over in federal court. So I was fighting on two fronts.
Yeah, right. And so I got to ask, when you were drafting the complaint, one, you got to see this stuff coming. So are you, how nervous are you, or how careful?
Very careful.
And then are you working it through with colleagues, or are you just gonna do this by yourself?
I'm gonna do it by myself. I mean, I've done a lot of coverage stuff. I felt pretty comfortable.
I love it.
I was very meticulous with my complaint of wrongful death, knowing I could not allege anything other than just plain old negligence to avoid giving them anything. I knew that was going to happen. I also knew the firm who typically represents Chubb, especially in coverage questions. Believe it or not, firm I worked in 25-something years ago, Swift Curry, a very wonderful, fine, reputable firm with great lawyers. So I called the guy I knew would probably represent Chubb. I say, hey, I'm getting ready to sue, explain the whole thing. I know Chubb is going to file a deck action. I want to talk to you about it. And over drinks, we talk about it. And I say, well, here's what I'm going to do. And so I did exactly that. And it turns out Chubb did not hire that firm, hired another firm that I was not very familiar with in Atlanta, a fairly new firm. But, in Georgia, that's what we typically do. If you know somebody who typically represents the opponent, you call them up and say, hey, I got this lawsuit. I'm giving you notice. I'm going to be filing, but maybe we can talk about it.
And so I think that's important, too. I know we do that in Missouri, and we're in the SEC now. Well, we've been in the SEC for 7 years now, but maybe that's a Southern thing. I guess but, for maybe. Anyone that's listening to this and you're thinking about this for the first time, I've always found it to be very helpful to reach out to opposing counsel that I think is going to be representing. I've done this multiple times.
I do it almost all the time if I know that person will be representing them, or typically does. So usually, you know the players, who typically represents a certain hospital or a certain insurance company, and you give them a call. In the Fox case we're going to talk about, same thing happened. I know the attorney. He and I are very close friends. I called him up and said, hey, you usually represent Emory Hospital. I'm getting ready to file suit. You want to talk about the case? And he very much appreciates that. It just sets the tone for the litigation. You don't need to be a jerk or take things personally in litigation. It's hard enough without being a jerk to each other. So we try to be cordial.
And I think that one of the things too is people, especially like newer attorneys, think that they have to pump up their chest or get really loud and outrageous. And lose sight of the fact that you're advocating for your client and what's in the best interest of your client at this point.
Correct.
Is it try to have a cordial relationship with the other side, or is it to try to alienate? And 9 times out of 10, it's cordial.
I agree.
Honey, track the flies, vinegar, not so good.
Absolutely. It works for your client's benefit. They may not realize it until it's resolved, but it does.
They don't. Sometimes they don't, right? Because then sometimes they're like, well, why are you being why are you being so professional?
I'll be nice to him.
Right.
Like, no, I'm just a nice person.
So you win the deck action, right? You win the deck action for the estate.
What happens is during the pendency of the deck action, the Court of Appeals remits it to Superior Court now. So I'm ready to ask for a jury trial. I'm ready to tee it up. Let's go. We're going to be talking about value to life. Because I think Tex would admit he accidentally shot his wife. He's never going to say I intentionally.
Right. Yeah.
He's just going to say, I shot her. It was an accident.
Sure. Yeah.
We're just talking about value to life. So I call the Chubb attorneys and say, hey, here's the remediator. I'm asking for a jury trial. What do you want to do? While we're fighting motion, they're filing all kinds of motions in the federal court case, the deck action. They suggest, to their credit, let's try to mediate. And we did. We did a global mediation with a fantastic mediator. And we worked on that day of mediation probably about 12 hours. Did not get it resolved, but the mediator kept working, and probably maybe 2 months later, we were able to resolve the case. And it was a global settlement, meaning when it was offered, it meant I dismissed my wrongful death case, and they dismissed the deck action, and it all goes away, which is what happened, except for Danny Jo Carter, who was the driver, if you remember.
Mm-hmm.
She retained a lawyer on her own and filed a cross-claim against Tex for intentional infliction of emotional distress. And they could not get that claim resolved at mediation. That is still pending.
Talking about gumming up the works.
It's still pending, and they can't get it resolved. And they had a hearing. There was a motion to dismiss it, and they had a hearing by Zoom, I think in April or May. So
Wow.
that motion's pending. Also, we'll see what happens, but that is hanging on. She claimed, the gunshot going off in the car just scared her so much, and the trauma and him telling her to lie and all that stuff was intentional infliction of emotional distress.
That's one of those law school torts that you learn about.
That's right.
It's never going to come up. And I
You
don't
never ever use?
Yeah.
up. Yeah.
Right. When is this?
I'll
never use this. I'll never use this.
I know, I have never even heard of a lawyer using it before. So,
well, now you've got a scenario if that ever happens to one of your clients.
So that's fine lawyering. You got it done without having a trial, but you try a lot of cases. I saw you on your bio, you tried 75. You've at least had 75 trials.
At least 75. It may be up to 80 now.
Which is remarkable.
I've practiced a long time.
Well, so I think Heidi had some questions about the Fox case.
Yeah. So tell us, before I get into my questions, I'm kind of a trial nerd, so I'm going to ask you more on the advocate side of that one. But before we get into that, if you'll just tell us kind of what happened in that case.
Sure. I represented the son of a woman, and the son's name's Marshall Fox. His mom's name was Jane Fox. And Miss Fox, Jane, went into Emory University Hospital on the advice of her pulmonary doctor because she had been a smoker for a long, long time, had quit maybe 10, 20 years before this incident, but had a tiny 6 millimeter spot on her lung that they were watching, had been there for years. Finally, the doctor says, we ought to biopsy that. And if it's cancer, it's going to be taken out. If it's not cancer, you don't even have to worry about it. And if we take it out and it's cancer, you won't even have to go through chemotherapy or anything like that. It'll just be gone. So she agrees. She's 74 years old, and she agrees to have this biopsy. Biopsy of lung is a very painful procedure to recover from, even though she would have had to spend one night in the hospital. That was predicted, one night. It's not really outpatient, but they do a surgery called a VATS, and that stands for video-assisted thoracotomy surgery. So they use a video scope, go in with trocars, these things that go inside your lung, to take out that spot to biopsy. A little tiny little piece of her lung. And it's on one lung, and so usually the thoracic surgeon, when he's operating on a lung, wants to stop that lung from breathing. So wants to prohibit air from going into that lung, even when you're intubated, and let the other lung breathe for you. He's working on one lung. It's a quick surgery. Doesn't take very long. That's typical. Although back in the old day, this is now the normal thing to stop one lung from breathing. But back in the day, there were thoracic surgeons who did it with the lung moving. They would just go in there and grab that little spot in your lung. The lungs being inflated, no problem. But now they use, and I brought, I wanted to show y'all. I know our listeners can't see it, but
we'll include it in the show notes.
This is
we can't include that in the show notes.
Yeah, this is a double. I don't know, but double lumen tube.
Sure. Yeah.
Double lumen endotracheal tube.
So you can look.
It's called a 35 French. They have their own lingo,
And that is going in the throat.
It's huge.
Yeah.
You see how big it is. And so this allows to stop up one lung, keep it from breathing while they operate on that lung. They ventilate the other lung with this double lumen tube. Same thing can be accomplished with a single lumen tube. Same thing. But this is easier for the surgeon, so they use it. The surgeon likes that big one better. Well, Jane was 74. She was 5 feet tall and weighed less than 100 pounds. So very tiny for an adult, really a child's size. But they still use this. And they hit her vocal cords. And they tried twice and couldn't pass it. So this has to go down your esophagus past your vocal cords.
Mm-hmm.
And then it branches off and stops one lung from breathing. They hit the vocal cords. They try 2 times and decide, we can't use this. She's too little. Pull it out, and they use this. See how small that is? Single lumen tube. And they successfully intubate her with a single lumen tube, much smaller, more flexible, not as rigid. Do the surgery. Get the little spot off her lung. She goes to recovery, goes to her room. She's going to spend the night. Well, by the next day, when she's supposed to be released, discharged, she starts to have a fever and starts to have a sore throat and coughing and some problems. And it gets worse and worse and worse. Can't get the fever under control. Now she's really complaining. She starts to have, and they note this in the nurse's notes, a wet vocal quality. So instead of sounding clear, she would sound like there's water or secretion in her throat. They do some, finally decide some swallowing tests. She fails the swallow test. And they start to think, I think something's wrong with her vocal cords. And maybe she's aspirating, and maybe she has pneumonia called aspiration pneumonia from secretions getting down into your lungs. It causes pneumonia. They discover she did have aspiration pneumonia. That was the cause of her fever, and that something was wrong with her vocal cords, just magically after surgery. They ultimately order a test called a nasopharyngoscopy, and this was a big part of the case, the nasopharyngoscopy, the ENT or otolaryngologist consult. The thoracic surgeon says, I think we need a otolaryngology consult. So he calls an otolaryngologist, which is a specialized ENT. ENTs are specialists, but otolaryngology is so small and specialized in America. There's only a few hundred of them in the entire nation. They call the otolaryngologist, and in Atlanta, in where Emory Hospital is, it's on Clifton Road. And Emory University Hospital, it's new, they have a new one now, but back then it was on this side, on the west side of the road. On the east side of the road is a children's hospital, CHOA, of Atlanta. When the otolaryngologist gets the call to do the consult, to do the nasopharyngoscopy, he's over at the children's hospital putting tubes in kids' ears all day in surgery. So he calls his resident and says, hey, I need you to do a nasopharyngoscopy on a patient over at the Emory Hospital. No problem. That resident goes over to see Jane to do a nasopharyngoscopy, and he does it about 7 or 7:30 at night. And there's another resident, and he's a second-year resident, and there's another second-year resident who's on anesthesia rounds, and she sits in and watches him. They do the nasopharyngoscopy. They don't record it, which is also unusual, but they do it, and this doctor, the resident, writes, abnormal, she's aspirating, she cannot protect her airway. When normal vocal cords close when you swallow, and that keeps any secretions or fluid or anything from going in your lungs, abnormal ones bow, so they never close when you swallow. And you can't even make them close when you swallow. And even when you're not trying to swallow, because they're bowed, normal saliva secretions go into your lungs. That's what was happening to Jane. So this resident writes she has abnormal bowed vocal cords called a glottal gap. That is called, that failure to go together is called a glottal gap, which means she cannot protect her airway. That's an emergency situation. When you can't protect your own airway, you have to have some intervention to protect it for you until your vocal cords can heal. Well, this resident writes it up and washes his hands, done. And says at the bottom of the consult, as they all do, call me if you need me. Well, no one ever goes back to see Jane. Bless her heart. No intervention, no suggestion about any kind of treatment to make her better. They literally do nothing. They change nothing about the game plan. They do one more test. They have a modified barium swallow, which was recorded. And you don't have to be a doctor to see the barium swallow material going in her lungs. Clearly, she's aspirating, and they create no treatment plan to make her better. She ultimately suffocates to death. They put her in hospice for the last 3 days of her life. She ends up never leaving the hospital and simply dying of pneumonia. So we brought a lawsuit, a wrongful death lawsuit, against the hospital, primarily for the actions of the anesthesia team that chose the wrong double lumen tube, endotracheal tube in the first place. It was too big. Shouldn't have attempted to pass it twice. Should have known not to try to do that, and injured her vocal cords. And the second part of the case was against the otolaryngology team for knowing she had an abnormal nasopharyngoscopy, knowing that she could not protect her own airway, and never offering any medical treatment. And that was the case. And that returned, the jury, DeKalb County jury returned a verdict of $2.35 million for the death of Jane.
So I saw in your case materials that Mike sent over that she died in 2014. Is that right?
Yeah, it sounds right.
How long ago did you try this case?
This was tried last year.
All right.
It was tried almost a year ago because, and the reason I know is I was scheduled, the trial lasted about almost a whole month, maybe 3 weeks. And I had scheduled a hip replacement on Monday, September 30th. And the jury was out for almost a week. And the jury's out. I'm like, I cannot miss my hip replacement. So I called a friend of mine who's a lawyer in Decatur to come in and receive the verdict in case I was in surgery. I was not going to miss I was in so much pain, I couldn't afford to miss the hip replacement. So the verdict came back, fortunately, on the 26th, and I had my surgery on the 30th. Thursday, had 1 day to celebrate, and then Monday had my surgery.
Yeah, I would hate it if you didn't get to receive your verdict after trying the case for that long.
I would hate it too, but it was that's the only thing I could do. I'm a sole practitioner, so I knew this attorney. He's practiced as long as I have. He could go in and know what, if he needed to make a motion or anything, he would know what to do. So I felt very comfortable if I had to do that.
Sure. So one of the questions I have is about your jury selection, and I call it voir dire. I'm from Alabama. I don't know if y'all call it
Most people here call it that. I call it voir dire.
Okay.
Because I went to Emory University, and that's what we called it at Emory.
Well, that's fair. So one of my questions about that is I'm always curious about different states' process. Because my state, we don't do where, there's some states that have like the 6 people come down and you voir dire those people and then they strike and then 6 more people. We do just the entire panel at one time. So how do y'all do that? How did it work in this case?
Same for us. We do the entire panel at one time. I don't know how many jurors came in at first, maybe 60. Mm-hmm. But because it was Emory, which Emory is the largest employer in DeKalb County, we're trying this case in DeKalb County. The judge and any employee of Emory before ever coming up to the courtroom. So that helped. But it's a wide open thing. The judge, and it's really up to the judge of how he wants to conduct it, but we're allowed a pretty full sifting voir dire. This voir dire lasted probably 3 days before we struck the jury. And the judge would ask what we call general questions, and you take notes on who's saying yes to what, and then each side gets individual questions. And there's no time limit on that. You can take as long as you want and try to strike as many as you need to strike and that sort of thing, for whatever reason. So it's pretty wide open, and we're very protective of our voir dire. We don't want to lose it. It's very important.
In Alabama, especially in Jefferson County, where I practice mostly, is kind of just the Wild West for voir dire, but we are limited. I mean, a judge would probably send me to jail for doing a voir dire for that long. So did you, and I'm curious about this because just of the way that things are going, but do you use a lot of tech in your trials, or are
Yes.
you, okay, what setup do you have for that?
Everything. Well, I use my laptop, but our courtrooms now have a device. I forgot what it's called, but it's like a Bluetooth device but it has a brand name. I just don't remember what it's called. But they have a device, and they have a TV. They have a TV and a big screen projector. You pull that big screen down, and you show everything on the TV at the same time using their Bluetooth connected thing. So I use my own laptop. I have my own TV that I can take to trial, but I believe part of your presentation as a plaintiff's attorney needs to be pretty quick and seamless.
Right.
And I have found moving that TV in and out just eats up time, and juries hate it. I like it better when my courtroom has the TV, and all of our courtrooms do now, but they have the TV and a screen, and I project it with my laptop. My paralegal is at trial with me for every day, and she helps pull that stuff up. I really don't like, now the defense, I know in Alabama and Georgia, almost always the defense hires a company to come in and do their stuff for them. Mm-hmm. And what I find is that the defense attorney has to say this constantly throughout his presentation, like, next slide, next, yeah, can you show the next thing, you know?
And it sounds so just
I think it's awful.
Yeah, it is.
I just let them do it, but I think it's awful. Mm-hmm. So I control my own PowerPoint. I've got a mouse that is, just put a USB in there, remote mouse. I stand, I do all myself. And I don't ever say next slide, please.
Yeah.
Can't stand that. Yeah. I think that's bad form, but.
Yeah.
So did y'all kind of, I'm wondering what, like what your approach to the trial was. Did you have a theme for it?
Yeah. Yeah, the main theme, and it was because of who Jane was. The main thing was they wrote her off. After doing the nasopharyngoscopy, they have all these abnormal tests that should tell a doctor something, right? I mean, that's why I asked one of their experts, well, why'd you do the test? If you're not going to do anything to help her, why do the test? And his answer was, well, we need the diagnosis. Well, so you're not helping her. Nobody said, how are we going to get Jane better and get Jane out of this hospital? So I said they wrote her off because the head otolaryngologist never even walked across the street to go see Jane. He's over making money, putting tubes in kids' ears. He sends the second-year resident. He never even bothered to walk across the street. And then he drives home. And part of that was, they testified that the resident told his attending about the abnormal nasopharyngoscopy. But the records show that they did not sign off. The otolaryngologist did not sign off until 2 weeks after Jane's death.
Oh, wow.
And that's pretty, I mean, why have a sign-off procedure?
Right.
If you're going to sign off after somebody dies, doesn't somebody need to see that before they die?
Right.
So Jane was a meticulous note-taker and journal. She loved journaling. She had journals. Marshall was in his 30s. She had journals going back to the day he was born.
Wow.
And we had all of them. We produced every single one of them, hundreds.
Oh, wow.
And she would write in tiny little script because she wanted to conserve paper. Mm-hmm. So we had hundreds of journals. She wrote every day. I showed in the last entry before she went in for this procedure, she was writing about how much she had spent at the grocery store that day, you know, fully cognitive, writing, keeping notes of what she's going to do when she gets out of the hospital. And then blank pages where she never got to finish that journal. And so I showed them that journal, and that was the way I closed, is they wrote her off. And every time I could show that they ignored her, they wrote her off. And then I pulled out that journal with the empty pages, and I said, you write Jane's ending for her. She died because of them, and she's not able to finish her story. You write her story, the ending of her story. That's the way I ended it.
Yeah.
And that's just, you know, each case lends itself to you about some theme that you gather, and that's what I came up with.
Yeah.
What a fantastic visual.
Yeah.
What a fantastic visual.
Something that you wouldn't know unless you really got to know your client. And, you know, I mean, that's just one of those things that if you don't really spend time with them, that's something that could have so easily been overlooked.
Oh, absolutely. And then you're talking about tech. The other thing we used to show, because they were arguing, one of their defenses was Jane was old and decrepit anyway. She was probably aspirating before this procedure, which is ridiculous.
She's old. She was going to die anyway.
She's old.
Yeah.
So what?
She probably poked herself. It just happens.
Yeah.
Right.
That's kind of a famous defense for them. But so we had a few voicemails that Marshall had saved on his phone where she's calling Marshall saying, hey, so-and-so is taking me to the hospital. I need you to pick me up at 8 a.m. and, all this detailed stuff. And her voice is very strong, clear. It's not wet quality. Mm-hmm. So we played those voicemails and admitted those into evidence. And I played them again for the jury in closing. And then we had goodbye videos that Marshall took while she was in hospice in her bed, where she's panting. She can't get air to breathe. She's literally dying before suffocating. And what she wants to do is make sure she says goodbye to all of her friends. And so she does goodbye videos and says, okay, this is for Debbie. Debbie, have a good life. I love you. Of course, she's barely talking. Mm-hmm. So we played all those goodbye videos to show the difference between pre-surgery and after they let her die.
Yeah. And I assume
which was pretty strong.
Was the defense trying to fight to keep some of those out, the videos?
You know what? They really didn't.
Really?
I mean, I don't think they could. We had the federal rules of evidence. Pretty much anything gets in, and Marshall authenticated them. So I think they realized there was no way. There was no way they were going to keep them out. So,
but something that powerful, you would think that they would at least try to come up with some arguments.
People were in tears. Jurors were in tears. People in the courtroom were in tears. I had called numerous friends to testify about her quality of life. One of her best friends, she would go down to a little town called Noonan, south of Atlanta, and just spend 4 or 5 days with her best friend. They go to festivals and, walk around and look at the different things for sale. I had her testify, and they are the same age. And that woman came in, smart as a tack, sharp, beautiful, well put together, and just told everything about Jane. And so did who was older than her. And her sister is perfectly fine. Drove herself from Alabama, from Bay Minette, Alabama, drove all the way up here by herself to testify. They were all sitting in the courtroom crying.
Yeah.
And then when you play that, there's not a lot you need to argue after that. It's common sense. You let the moment kind of have it and be in silence. But, talking about this kind of common sense about using that double lumen tube on such a small person when they should never have. I had the anesthesia assistant, not a doctor, who intubated her on the stand. And I just held this up and I said, doctor, come on, man. Isn't it common sense not to use this on a woman who weighs 95 pounds? It's too big for her. It's common sense. He goes, oh, we don't use common sense. He said that because, they use some mathematical formula or this is the standard, so we're going to use this. So every time I could in closing, I said, y'all get to use your common sense. You're not like the anesthesia assistant.
That's right.
You're not like the people at Emory. You get to use your common sense. So use your common sense. Was she aspirating before this, or did they do that to her? So,
and one of the things, so the double lumen almost looks like a roll of dimes or like a dry erase marker, about the size. and then to compare the single lumen is about the size of a pencil, effectively.
Yeah.
And
the other thing was good. Yeah. Much smaller, flexible. The other thing, I had the measurements.
Let me ask you this. Are you handing that to the jury in your opening statement? Is that something that you're using as a demonstrative in your opening statement?
Well, use it as demonstrative, but we actually admitted these. I mean, they had them in the jury room. We admitted them into evidence, so they could play with them. And I urged them to feel how rigid this is. I would bang it up against the jury box and show them how hard and rigid it is and how easy and flexible this is. I was going to tell you that, on X-ray, they measured her left mainstem bronchus, which is that little air tube that goes into the left lung, as 12 millimeters. 12 millimeters. Well, this is 11.7.
Oh, wow.
11.7 millimeters. So they had 0.3 millimeter room for error. That's nothing.
Nothing.
So, when a jury sees that, you don't have to be a doctor to know that was a dumb decision.
Right.
You don't have to be a doctor. You don't have to have all that education.
That's right.
So,
and I have one quick question for you about
Yep.
your experts. The trial was 3 weeks. How did you balance when you're talking with the experts about their qualifications? I always like to know this from med-mal attorneys, when you're talking with them about their qualifications versus just getting right to their opinions and trying to keep the jury locked in on what's important.
Very minimal patients. That's my recommendation. That's what I do.
Yeah.
I think the jury feels that if a doctor comes in there, raises his hand, and says, "I'm a doctor," that's what they need. It's very minimal. I don't go into articles they've written. I don't do any of that for my experts.
Sure.
I talk about it's really short, maybe 10 minutes of qualifications, and that's it. Now on their doctors, defense attorneys do a lot more, and my cross is all about credentials and articles they've written. If they've written one word that's in the opposite of what my case says, what the case is about, if they've written anything opposite of their testimony, it's going to be crammed down their throat. And that if they've written 500 articles, I will have read 500 articles. I know every article they've written and that sort of thing. But on my witnesses, I don't do much. I have found defense attorneys don't cross-examine them too much on that either. I don't know why, but they don't. But jurors they don't need much. Jurors feel like they're all doctors. They're all qualified and let it go.
Let's get to it.
It's just too boring and you just lose the point. You want to get to the point.
Yeah.
I want my experts to say their opinion almost like the first part of their testimony.
That's great.
Say who they are, where they practice. Okay, here to testify to say what.
Yeah.
Have them say their opinion. And then you can get in the nitty gritty, but no.
And we'll include the demonstrative that you used, which was the timeline of her treatment.
Yeah.
Was that effective?
I think you have to have it. It helps me, but if I just gave them dates and times, I think it would be lost. I like to put it up there. I like to identify it. I had 2 what I call critical points of error. So I always in a case have a critical point of error. These 2 things that were critical points that they could have changed the course of this case. They could have saved Jane these 2 points and they didn't. And those are shown in red or with fire around it or something to distinguish them. But Jane went in the hospital and was in the hospital for 6 weeks and never left. And I wanted that visual of timeline of 6 weeks of suffering, because once she got out of the surgery, she went downhill and suffered for 6 weeks. So technically that is pre-death pain and suffering. So I wanted that timeline for that element of damages, but it also gives you a great idea of every single day she suffered. In fact, spent her 75th birthday suffering in the hospital. One of the things made clear is that Emory has a hospice on the top floor of its hospital, which we thought was a little too convenient. You make a mistake and send them up to your own hospice.
Yeah.
And that's what they did. I don't particularly like that idea, but that's what they did. So, she died in hospice suffering. There was a point of no return, a point where they could not redeem her vocal cords. They knew she was going to die. Her throat was killing her. And she started begging for ice cream. And you just imagine that poor woman begging for ice cream, suffocating, and they refused to give it to her because she was aspirating, even though she was not going to recover. Now, is that negligence? No, that's not negligence. But man, you tell that to a jury, they get mad.
Yeah, sure.
They don't like that. And I wouldn't like that.
Well, I just really grateful that you not only took on the case involving Tex to do some justice in that case and hold the value of a life up, the standard of the value of life up in Georgia, but also for Miss Fox. And so and also grateful that you came on to talk with us today about both those cases.
It's been wonderful and lovely talking to you about, and thank you again for having me.
If someone was wanting to reach out to you, what's the best way to get in contact with you?
My website is gatriallawyers.net.
Okay.
And I have a way you can get in touch with me there, or my email is robinclark@gatriallawyers.net.
And we'll have both of those in the show notes. All right. Robin, thank you so much again for coming on.
Thank you. It's great.
You're listening to the Case Autopsy, the Verdict and Settlement Podcast. This is Mike Campbell.
Wow. She's incredible.
She is. She's awesome. I love those ideas that she had about the themes for her jury trial. That's just something that I'm not great at coming up with those, but she clearly has a talent for it.
She's doing this on her own too.
Mm-hmm.
And she's not only wanting to do it on her own, you can tell she's not only very confident, but very good at what she does.
Yeah, absolutely.
She's the type of person that if I were injured in Atlanta or anywhere in Georgia, she would be the person I'd want to help me out.
Yeah, she's kind of my role model now.
I mean, mine too. She's awesome.
Yeah,
and the powerful, the demonstrative, just the journal, and your point that you don't get that information without spending some time with the client, learning about the client.
Right. And I love that. And I was hearing her talk about, her client taking notes and everything. And I didn't really see where she was going. And then she started talking about the blank pages. And I was just like, oh, wow, wow.
Hit you.
What a way to end a trial.
It hit you right in the feels.
Mm-hmm.
Yeah, that is so good. I mean, have you found that to be important in your practice, to get to know your client more than just, the case name, case file? Just spend some time with the client to get to know.
Yeah, and I've not always been great about that. I work at a firm that we do a lot of volume, and so it's hard to get that deep with your clients. But every time that I have, it's always changed the way that I try the case.
Right. Yeah. It's important to just get to know the person and to understand the story. And we recently did a one-day workshop with one of our clients that we have a trial coming up on. Hopefully we'll get it in this year. It's been continued now twice. And we learned so many things about what motivated this guy. And it's just, I think, hopefully going to be apparent to the jury that, we're speaking for him and not for ourselves.
Right.
So, if someone wanted to get a hold of you, Heidi, wanting to talk with you about a case down in Alabama, what's the best way to do that? Call
my office. My number is 205-983-8132, or my email address is hdilorenzo@asilpc.com.
I'll put that in the show notes as well. And Heidi, you were gracious enough to do an interview with Lawyer Minds. I would recommend that everybody read that. And if you are thinking about doing some sort of education, check out any AAJ education seminar where Heidi's on faculty. She's outstanding. I've watched her present and learned a lot from you.
Well, thank you. I appreciate that.
Thank you.
All right. Well, thank you for having me. This has been a lot of fun.
I'm looking forward to another one.
Yeah, absolutely.
That concludes another episode of Case Autopsy, the Verdict and Settlement Podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.